Maritime Academy. General info for masters. Manning and STCW requirements. Safe manning certificates are only issued by the ship registry after consultation with the owner or manager. The Safe Manning Certificate will state the numbers and categories of officers and crew members that are required to be on board. The crew numbers on board must never be allowed to go below the minimum as stated in the certificate. If due to unforeseen circumstances, a seafarer has to be repatriated from the vessel and a replacement cannot join the ship in time, it may be possible for the vessel to continue to operate with one less seafarer than is specified on the Safe Manning Certificate for a maximum period of 21 days by some flags. This is only permitted after the flag has been contacted and an assessment is made of the vessel's manning levels, after which express permission may be given. Dispensation letter. All officers who do not possess a ship's flag certificate of competency must have a valid STCW 2010 endorsement document issued by the ship registry. If an officer does not have an endorsement when he joins, then you should check that an endorsement has been applied for. Applications are made by the owner-manager, and if an application has been made, a stamped confirmation from the ship registry will be available. An officer can only sail on board ships without a valid endorsement for 30 days, providing evidence of such application can be shown. All deck and engine room ratings assigned to watch-keeping duties must be in possession of watch rating certificates appropriate to their duties. Watch rating certificates issued by countries other than flag are quite acceptable provided they are issued by countries which are parties to the STCW Convention. If a rating has sufficient sea service, meets the minimum age requirements, and can demonstrate his competence in the areas listed in the STCW Convention, then Master or Chief Engineer, as appropriate, can issue a provisional watch rating certificate, which is valid for 3 months. Crew agreements and official logbooks. Every ship has to have a special agreement in writing between each person employed and the company employing him. These are known as crew agreements, and they are required to be in writing and in a form approved by the ship registry. Most ships are required to carry and maintain a document called an official logbook. This logbook is a legal document and is an official channel of communication between the master and the ship registry. It is also a document which is acceptable as evidence in court proceedings. Therefore, it is essential that it is regularly, correctly, and accurately completed by the master, or in his absence, an appointed deputy. Records of seafarers employed, musters and drills, testing of steering gear, inspections of accommodation and provisions, details of drafts and freeboards on departure and arrival port, returns of births and deaths on board are to be written in it. Salvage agreement and SCOPIC. Types of salvage agreement. Lump sum. The amount of salvage charge is fixed in advance. Daily hire. The amount of salvage charge will be calculated on a daily hire basis. No cure. No pay. The amount of salvage remuneration will be decided after the salvage operation, based on the salved value of the vessel, cargo and other property salved, etc. The salvage remuneration will be covered by property H&M and cargo underwriters, not by P&I Club. The special compensation and payment to the salvors under the scopic clause, the scopic remuneration which exceeds the salvage remuneration, shall be covered by the P&I Club. The main idea of the scopic clause is as follows. A fair amount of salvors' costs is calculated by the agreed tariff, scopic tariff. Scopic remuneration means the total of the salvors' costs calculated by the scopic tariff rates plus a standard uplift of 25%. Scopic remuneration is calculated after the salvors invoke the scopic clause. If the salvage remuneration is less than the scopic remuneration, the salvors will be entitled to receive the balance from owners. If the salvage remuneration is more than the scopic remuneration, the salvage remuneration in excess of the scopic remuneration will be discounted by 25% as a penalty. Once the salvors invoke the scopic clause, the owners shall provide security, a bank guarantee or P&I Club letter, for $3 million to the salvors within 2 working days. Scopic remuneration will be assessed by the SCR, Special Casualty Representative, nominated by owners. Loss of or damage to property of a third party. During berthing, unberthing operation of a vessel, it sometimes causes damage to jetty or quay itself or to facilities such as fenders, stoppers, bits, cranes, unloaders, loading arms on quays, etc., due to mismaneuvering, excessive speed, insufficient lookout, and so on. In other cases, the vessel may cause damage to port facilities such as breakwaters, navigational facilities, buoys or beacons, structures, underwater cables, underwater pipelines, aerial cables or drilling rigs, or fishing facilities, fixed nets, fish preservers or fishing beds, etc., due to dragging anchors or mismaneuvering. These are risks covered by P&I insurance. Loss of or damage to the other vessel without contact. Liabilities arising from collisions in respect of the damages to the other vessel as well as its cargo are covered by Running Down Clause, RDC, the Collision Liability Clause, mainly provided by hull and machinery underwriters. Sometimes at the moment of near miss, the other vessel takes evasive actions to avoid a collision, and consequently, it may run aground and suffer damage. In other cases, during navigation in narrow passages, the vessel's surge can cause damage to adjacent vessels, jetties to which they are moored, and facilities on the jetties. These situations that there are no direct contacts between vessels are not categorized as collisions. Therefore, such liabilities which the vessel should assume to the other vessel are not covered by RDC, but covered by P&I insurance. Evidence to be collected. Wash damage. Whether the pilot had made the master or any of his officers aware of any speed restrictions in the area. Whether the master or any of his officers were aware of any speed restrictions in the area. Whether the pilot was made aware of any speed restrictions by the master or his officers. Justifiable diversions. A diversion from the usual and customary route will normally be considered justified if necessary to land ill or injured crew members, passengers, stowaways, refugees, or persons rescued from the sea, or to save life or property at sea. The company will often be under a duty to divert in such cases, and there are international regulations which oblige the master to render every possible assistance to save life and property at sea, e.g., a vessel in distress. The P&I insurance normally covers the company for certain extra costs incurred in justifiably diverting a ship in the circumstances. If circumstances allow, the master must seek instructions from the company and the P&I insurer before diverting the vessel. Assistance can also be sought from the P&I insurer's local correspondent. All the circumstances that cause the master to divert the vessel should be recorded. Diversion to undertake repairs. In case of damage to or failure of any part of the vessel's engines or other parts which require repairs at a port en route, both the hull and machinery and P&I covers may be involved. Consequently, the company must be informed, enabling them to contact both insurers. The hull and machinery insurer may wish to instruct a survey or to inspect the damage. Evidence to be collected in all cases of diversion, deviation. Date and exact time of diversion, deviation. Position where the vessel commenced the deviation. Speed, propeller revolutions, or propeller pitch of the vessel. Amount of bunkers, other fuels and consumables. Any records of events having caused the deviation. Date and time of arrival in the port of call. Duration of stay in the port of call or intended position. Date and time of departure. Course and speed until the vessel arrived back in the same or equidistant position. Amount of bunkers, other fuels and consumables at the time the vessel was back in equidistant position. Courses steered. Fines, criminal investigations. When a fine is imposed or threatened to be imposed, the cover provided by the P&I insurance may be involved. Criminal investigations. If the master is investigated by the authorities for criminal misconduct, he or she or any other person involved may have the right to remain silent and the right to seek advice from a lawyer before responding to any questions from authorities. If a demand for payment of a fine or a request for a guarantee is made, the master should notify the company and the local correspondent seeking their assistance. If the fine is not supported by official documents from a relevant authority or court, the demand should be politely but firmly rejected. No admission of liability should be made without consulting the company, the P&I insurer, the correspondents, or lawyers instructed on behalf of the company and the crew member involved. Grounding immediate action. Reference should be made to the emergency contingency plan. Watertight integrity of the vessel should be assessed. All tanks must be sounded to check for water ingress. Make an assessment of the forces on the vessel's structure, taking into account cargo distribution and prevailing tides and weather. Proper navigation lights or shapes must be displayed. Radio warnings should be broadcast to vessels in the vicinity of the grounding site to keep clear. Consider attempting to refloat. Pollution. In case of pollution, owners, masters, chief engineers, or other officers or crews can be penalized or even imprisoned. Under CLC, the owners of dirty tankers which cause oil pollution are held liable for the pollution damage whether or not the masters or crew are at fault. This is referred to as the strict liability principle. The owners are entitled to limit their liability in accordance with the provisions of CLC or LLMC convention. Insurance cover. The cover provided by P&I insurers is involved when pollution occurs. P&I insurance covers damages caused to third parties due to oil pollution and/or costs and expenses incurred by the owners for preventing and/or mitigating the damage and/or cleaning the oil spilled. If the pollution is caused by the escape of oil from the other vessel following a collision, the cover provided by the hull and machinery insurers, other than on UK standard insurance conditions, may be involved. If this is the case, the hull and machinery insurers or their correspondents must also be contacted. If there is pollution, the master should refer to and implement the relevant SOPEP for the particular jurisdiction in which the pollution has occurred. Cooperation with authorities, no admission of liability. No chemicals to be used unless approved. Chemical dispersants must not be used following an oil spill unless and until their use has been approved by the local or national authorities. Damage to owned ship by third party. Damage to the owned vessel may be caused by stevedores during cargo operations, shore terminal operators with cranes, contractors during works, truck drivers on ro-ro vessels or any other person being on or next to the vessel, such as supercargo agents, visitors, etc. The company and the hull and machinery insurer must be contacted. Actions to be taken. Make immediate reference to the vessel's emergency contingency plan if this particular type of damage is described in the plan. Notify the responsible person within the stevedore's company. Inform the relevant local authority or ashore. Inform the company and correspondent to arrange a survey. Stowaways. When stowaways are discovered on board, the cover provided by the P&I insurers is involved. Contact should therefore be made with the company, the P&I insurer, or their local correspondent. When stowaways are discovered on board the vessel, the master should refer to the procedure contained in the emergency contingency plan under the vessel's SMS. Stowaways actions to be taken. Should be placed in a locked cabin. If possible, be accommodated separately. The place where the stowaway was found should be searched for further stowaways and any documents left behind. The stowaway should be searched for identity papers. The stowaway should be thoroughly searched for drugs. The stowaway should be questioned in detail as to when and where the boarding took place. If there is more than one stowaway, they should be questioned individually. Immediately notify the company and the P&I insurer, enabling the CSO to inform the appropriate authorities at the next port. Notify the correspondent and the vessel's agents. Video evidence of the treatment of the stowaway should be taken. Continuous synopsis record. This is a form of logbook that stays with the ship for its whole life and records all changes of owner, flag, name, class, ISM, etc. Whenever a change occurs, a new section or a new document is issued, and then each has a consecutive number. If a ship is sold, this document must stay with the ship. As master, you are responsible for the proper upkeep of the CSR on board. Port State Control will check the CSR as a matter of routine at inspections. Making amendments to the CSR. When any data entry in the current CSR requires an amendment, you must act as quickly as possible. To do this, you should fill in the changes on the Form 2 and send this to the ship registry. The ship registry will enter the new changes in the ship's master record and issue a new CSR sheet with the next consecutive number to be attached to the record on board. After this is done, you must ensure that the index of amendments, Form 3, is kept up to date and also attached to the current CSR in date order. LRIT. All vessels of 300 gross tons and over are required to have a LRIT fitted and functional. This little box sits out of the way and it is monitored by your service provider. A conformance test report should be issued on satisfactory completion of a conformance test by the administration or the application service provider, ASP, who conducted the test acting on behalf of the administration. When it is permissible for a vessel to cease LRIT transmissions. Where the vessel is in dry dock or undergoing modification in a shipyard or port for a period where continued interruption of the system would cause undue problems and an application has been made to the ship registry and agreement received. Where the vessel is to be placed in long-term layup and an application is made to the ship registry by the operator to reduce the transmission rate or to stop transmission for a set period and agreement received. Golden rules of berthing. Passage planning. Berth to berth. Risk assessment, fully brief the pilot. Pilot to discuss berthing plan. Working with tugs. Wind and current, wind age area, and number of tugs required. Bow thruster. Maneuvering. Avoid high forward speed. Test astern movement. Kick ahead. Ship's pivot point. Point of influence of wind. At low speed, current and wind have a greater effect. Never ring finished with engines until every mooring line has been made fast. Always anticipate well ahead and expect the unexpected to occur. Maritime Academy